Open the roll for attendance, please. All right, I believe we have a quorum. We've got 10 bills to hear in committee today. I'd like to start with Delegate Adams, House Bill 239.
Thank you, Mr. Chair, members of the committee. You have before you House Bill 239. I believe there's a technical amendment that will help align this bill with the Senate companion bill. Is that something like ask the clerk?
Yes, Mr. Chairman. On line 5, in the title, after the word include, strike older Virginians and insert adults 65 years of age or older. On line 14, after the word include, strike older Virginians and insert adults 65 years of age or older. And on line 16, after housing 4, strike older Virginians and insert adults 65 years of age or older.
If everyone understands those amendments, is there a motion?
So moved.
Second.
Motion second to accept the amendments. The bill is before us as amended. Delegate Adams.
Thank you, Mr. Chair. And this bill is brought to me to put forth by the Joint Commission on Healthcare. The U.S. Census Bureau estimates that nearly 24% of Virginia's population will be 60 years of age or older by the year 2030. And the Joint Commission's healthcare report found that one of the greatest unmet needs for older Virginians is affordability of housing. Virginian ages 65 and older make up 22% of the population of Virginia, and they also account for 44% of low-income, rent-burdened households. This bill expands the existing Housing and Supportive Services Interagency Leadership Team to include older Virginians as a target subpopulation in current housing initiatives and to seek their input to assist in developing strategies for increasing the supply of permanent supportive housing for older Virginians. The Housing and Supportive Services Interagency Leadership Team is a collaborative effort by the Virginia Department of Housing and Community Development that was established to aid in the creation of and implementation of DHCD's goals that include increasing permanent supportive housing for people with intellectual and developmental disabilities, people with serious mental illness, and people experiencing chronic homelessness. As I mentioned, this legislation was a unanimous recommendation from the Joint Commission on Healthcare.
Thank you, Delegate Adams. Is there any questions from members of the committee? All right. Anybody here to speak in favor of the bill? Anyone in opposition? Do we have anyone in the virtual queue? All right. Any last words, Delegate Adams?
Please support the bill.
Thank you. Looking for a motion.
I have a motion to move to report.
There's been a motion to report.
Second.
And second. And there is a note to send this to appropriations, so if that motion could be amended.
So, Mr. Chairman, I withdraw my original motion, and it's to report and refer to appropriations.
Thank you. Is there a second?
Second.
All right. It's been moved and seconded to report to and refer to appropriations. Clerk, please open the roll. Oh, as amended.
As amended.
Get used to this soon. Maybe not. All right. Thank you, Delegate Adams. That report's 7-0.
Appreciate it.
All right. Let's see. Next, we'll take up Delegate Converse Fowler. I think you have 4 bills in the docket today. Whichever is your pleasure to start with.
Mr. Chair, could we start with the lowest number?
Sure. 376, House Bill 376.
Yes, House Bill 376. Thank you, Mr. Chair and members of the subcommittee. HB 376 makes an adjustment to the Virginia Residential Property Disclosure Act by requiring this form to include a statement to be signed by the parties acknowledging the purchaser has been advised of the disclosures listed on the board's website. A statement referring you to look at a website for all the required state disclosures is not adequate. I brought this bill up before, and it just is not adequate. Buyers do not go on to the website to look, and if they are going to fully be disclosed their rights, they need to be given a copy that they sign. A copy that they sign is pretty easy. DPOR already makes the copy. It just needs a signature line. I know there is some opposition, and I hope it would be the will of the body to empower our home buyers and protect them and strengthen consumer protections in the Commonwealth.
Thank you. Are there any questions for the patron from members of the committee? All right. Anyone here to speak in favor of the bill? Anyone to speak in opposition to the bill?
Mr. Chair, I did have speakers to come speak for it, but I didn't. I just got noticed yesterday afternoon, so I wasn't able to get them here.
Okay.
Sorry about that.
That's okay. Have one, and if you would state who you are, who you represent, and your position on the bill.
Thank you, Mr. Chairman. Erin Barton with the Realtors. We oppose this bill. Currently, we have a form with a link that directs the buyers to a website maintained by DPOR that lists all of the items a buyer should research or be aware of before purchasing a home. And as the committee knows, this list of items is changed or updated every year. So to minimize issues where a licensee may inadvertently use an old form without the current changes, which would potentially jeopardize the transaction and affect the buyer's ability to go through the list, the General Assembly moved to an online link years ago. The concerns that led to that, that's okay, to that change still exist, and we therefore oppose going back to a written form and foregoing the link, which is the current law. And I'm happy to answer any questions.
I have a question, Mr. Chairman.
Delegate Fowler, please go ahead.
Thank you. I'm just curious, the only house I've ever lived, I built myself, so I didn't really have to sign anything. So what are all the list of things you have to sign now?
So the list is called the Buyer Beware Form. It's in the Residential Property Disclosure Act. I definitely cannot recite the whole list for you. It's very long, but it has items such as a buyer should get an inspection, a buyer should find out if they're in a historic district, a buyer should find out if there's a stormwater retention facility on their property, or it goes on and on and on, and it changes every single year, which is why they now get a shortened form with a link on it that directs them to the DPOR site where they can see the most current and updated list. And they do have to sign that form saying that they've been given it and understand it. So.
Right,
Thank you, ma'am. Is there anyone in the virtual queue to speak in favor or opposition to this bill? Okay, thank you. Delegate Converse-Fowler, you amended this same code section, was it last year or the year before, to include the website language, correct?
Mr. Chair, no, I was trying to do the same thing last year.
Okay.
Keeping it all on one form. There are about 10 to 11 things that are buyer beware. And then there are separate things, and DPOR does an excellent job with their form on their site, where then on the last page it's blocked off and it says these are the things that you would have to be given a separate disclosure for. It's very clear, but you don't have to sign it. You have to sign a separate form that says the link and that you saw it, or that you been given that information. I think it's meant to hide some information. I think it's meant to confuse buyers and renters and people who are looking at the property. They don't know their rights, and it puts a lot on the real estate agent when we could just put it all into one form. I'm a broker. I own my own real estate firm. I have all military spouses that work for me. We've been through this dozens and dozens of times, and what happens is big corporations that deal with this, like RAIN, the multiple listing service in my area, they don't want to deal with this, and they end up creating their own form, which buries it into more disclosures. So now you've got a 10-page document, and my buyers and our sellers don't know what they're looking at. So requiring the state-required form to actually be given to them, which is very clear, is something that I will continue to fight for every year for my clients.
Thank you, Delegate Converse-Fowler. This committee operates by motion.
Mr. Chair, I move to gently lay on the table.
Second.
It's been motioned and seconded that we gently lay this bill on the table. I believe that's a recorded vote. If you could please open the roll. All members cast their votes. This bill is laid on the table with a 7-0 vote. Please proceed, Delegate Converse-Fowler, with House Bill 382.
Thank you, Mr. Chair. I'll try and speed it up then. HB 382 is ensuring that all members in good standing with their property owners association are empowered, treated fairly, and guaranteed the equal right to present use and enjoyment of their property. It allows any property owners to gain access to audio-video recordings as well as knowledge of any pending or probable litigation involving the association. Right now in code, you have to be given notice of probable litigation when you buy a new home or when you get the disclosure package. But there's no requirement to give you any information as a homeowner when I call and I say, is there any pending litigation? There's no requirement for that anywhere. There is opposition again to this, but I will say that I can answer any questions or if there's any issues brought up, I can talk about them. I'm heavily involved in our HOA as well as my husband, and I pretty much look at it constantly. So, Mr. Chair, I hope it is the pleasure of the subcommittee to pass it and send it to full committee.
Thank you. Are there any questions of the patron on House Bill 382 from the committee? Seeing none, do we have anyone to speak in favor of the bill that's here in person? Is there anyone in person that wants to speak in opposition to the bill? If you could identify yourself, your association or interest, and your position, please. Thank you.
Sure, Mr. Chairman. My name is Pia Trigiani. I practice law in Northern Virginia. I'm a member of Community Associations Institute, and I'm here on behalf of the Virginia Legislative Action Committee of Community Associations Institute. We oppose the bill. The legislation seeks to amend a code provision that was added to the code a number of years ago to reflect in one place the rights of homeowners. This bill extends those rights and increases some of the obligations placed on common interest community associations. Specifically, the first, equal rights. There are no equal rights, unfortunately, in a common interest community association. Those are governed and limited and restricted by the contractual obligation established in recorded covenants and restrictions. Those are limited very specifically. There is not an equal right. And in fact, some owners may have less rights than other owners, depending upon how the documents are drafted. The right to receive notice of any pending litigation is typically driven in the documents, the governing documents for a property owners association. Here, this bill only seeks to amend, by the way, the Property Owners Association Act. There is a parallel provision in the Condominium Act, and this would make those two statutes uneven. We try to keep them parallel. But this provision would also require, and in some instances it's impossible to provide information on litigation. As an example, community associations often have a very active assessment collection practice against individual owners. The community association cannot provide information on that litigation because it's a violation of the Federal Fair Debt Collection Practices Act. So there are instances when, in fact, that an association would be in violation of the law if they did provide information. We believe the bill's unnecessary. We can't cite any specific instance or when this has been an issue for any community association. We've not heard it from any other area within which we operate, so we would respectfully request that the bill not move forward. Thank you. I'm glad to entertain any questions.
Thank you. Is there anyone else here to speak in opposition to the bill?
Mr. Chair, members of the subcommittee, Nicole Brenner with Reed Smith on behalf of the Virginia Association of Community Managers. I will be deferential to your time and associate myself with the comments of Ms. Trigiani.
Thank you. Is there anyone on the virtual queue to speak in favor of the bill? Is there anyone on the virtual queue to speak in opposition to the bill? All right. Seeing none online, Delegate Converse Fowler, you have the final word.
Mr. Chair, if I could correct something on number 6, it says the right to serve on a board of directors if duly elected and a member in good standing of the association. That was already in the existing code. The addition was, and to carry out one specific duty with the same rights and privileges as other board members, unless the declaration provides otherwise. And Ms. Trigiani should know, because she represented our association, that my husband was a board member and was not included in conversations. There was a lot of issues. I think board members have the right to the same rights and privileges as other board members. We have quasi-governments going on. Quasi-governments that are deciding things for neighbors that I don't think anyone realizes how out of control they are, especially in my area. They need to be reeled in. I do have another bill that is a study that would look at this. I've looked at the history of it, and it might be a good way for everyone to get a good idea of what's going on, but this is all from, this has been going on for years in our HOA, and I think there is some merit to giving owners a right. I would love a friendly amendment that fixes, number one, the equal right to present use and enjoyment of the property, maybe of their own property, the owner's property versus just the property. I think that was an issue that was brought up, but other than that, I thank you, Mr. Chair.
Okay.
Mr. Chairman.
Delegate Bolova.
Thank you, Mr. Chair. I actually did have just a kind of a technical question for Ms. Trigiani, if she wouldn't mind. And this regards, I guess, line 31 and new proposed section 7 or item 7. And so I certainly understand that if you've got pending or active litigation, that those aren't things that you just go ahead and divulge to anybody who goes ahead and asks. I am curious whether just the fact that there is pending legislation or active legislation. So if somebody went ahead and asked, would it have to be revealed that there is something out there in that is actually a record under, I guess, number 2 or that top clause?
Thank you, Mr. Chairman. Yes, is the answer to Delegate Bulova's question. It would have to be upon proper request. Any book and record of the association is available and accessible to any member in good standing.
Okay, thank you.
Any other questions from the committee? All right, this committee operates by motion. Is there a
Mr.
motion?
Chairman,
Yes.
motion
Go ahead.
to gently lay House Bill 382 on the table.
Second.
There's been a motion and a second to lay House Bill 382 on the table. That's a recorded vote. If the clerk could open the roll. All members have cast their vote. That bill is laid on the table with a 7-0 vote. Delegate Converse Fowler, if you could continue with House Bill 954.
House Bill 954. Thank you, Mr. Chair and members of the subcommittee. It's no secret that the pandemic has caused us to reevaluate how we conduct business and how we meet in our respective organizations and communities. HB 954 would codify the need for virtual participation if needed by a member and a board member via telephone or video conference. It will also allow business to continue and progress by allowing virtual participation to be deemed present for quorum and voting purposes. Our lot owners have every right to be involved in the business of their association. Their participation should not rely on whether they can be physically present. And I apologize, there was a amendment, and I forgot, Mr. Chair.
Please report your amendment.
Mr. Chairman, on line 41, after if a strike member, insert director. On line 42, after such strike member, insert director. And on line 43, after conference, period A, strike member, insert director.
Thank you. Is there a motion on those amendments? It's been moved and seconded. Those amendments are before us. Delegate Converse Fowler, please proceed.
Thank you, Mr. Chair. What we did last year was we allowed virtual meetings. We took out the section that said two directors had to be in person.
Got it.
If we wanted to have anybody participate on the phone, we removed it. So now we don't allow any phone unless the board then decides. So as my husband was quarantined and ill in October, he was not allowed to attend any meetings. And the resolution written to allow that was written by their attorney. So right now it is allowed in code for directors they don't have the right to participate. So if a member is incapable or otherwise unable to be physically present, they have a right to serve on their board. So it just seems commonsensical to give them the opportunity and give them that right to do it, which we took out before. Thank you, Mr. Chair.
Thank you. Is there anyone here to speak in favor of this bill, House Bill 954? Is there anyone to speak in opposition to this House bill?
Mr. Chairman, again, Pia Trigiani on behalf of Community Associations Institute. I'd like to clarify that I'm here on behalf of thousands of homeowners who are members of Community Associations Institute across the Commonwealth. We have 8,000 plus communities registered with the Common Interest Community Board, and I no longer represent the association to which the patron referred earlier. This bill seeks to amend a bill that was Delegate Bulova's bill last year, which enabled Common Interest Community Associations to meet electronically, both their boards and their members. This bill is working. It passed both the House and the Senate. On the Senate side, Senator Donovan carried the bill. It's a bipartisan bill. It came out of both houses without a no vote. It has enabled all community associations to meet. There is a requirement, and a steep requirement, that every community, if they wish to meet electronically, whether the board or the members, the board must adopt guidelines. Those guidelines are designed to protect and ensure that each member who has a right to be at the meeting can be at that meeting and participate in that meeting, including members of the board of directors. The bill is unnecessary. The legislation is working and working well, and in fact fostering greater participation, not less participation, in this form of government, if you will. We don't like to call it that. We prefer it to be a business, because most of these are either incorporated entities or unincorporated entities that conduct business like a company that owns millions of dollars in assets. One of the communities we represent is larger than my hometown in Virginia, Big Stone Gap, with 7,600 homes, and they operate on a $12.5 million annual budget. Wow. And so, they take care of, manage, make sure their members are able to access 5 pools and clubhouses. They operate in the open, very transparently. In this bill, thank you, Delegate Bulova, has enabled us to do that in these very difficult times.
Thank you. Is there anyone else to speak in opposition to the bill?
Mr. Chair, members of the subcommittee, Nicole Brenner with Reed Smith on behalf of the Virginia Association of Community Managers. We manage in excess of 600 communities and 500,000 units throughout the Commonwealth. We also oppose the bill.
Thank you. Is there anyone in the virtual queue to speak in favor of the bill? Is there anyone in opposition? All right. No virtual today. Delegate Fowler, you have the final word.
Yes, Mr. Chair. I think one thing that I would want to correct is this bill would reinstate that the board can call in, just like if you were late or you were at a Boy Scout meeting or you had a reason, you could call in and still participate and serve on your board, which is your right as a duly elected board member. We took that out. So, I would even question and ask how this bill is working when my husband served on the board and was not allowed to attend meetings while he was in quarantine and when he was very ill in October and in the hospital. Thank you, Mr. Chair.
Thank you, Delegate Congress Fowler. Is there a motion on this bill?
Move to gently lay on the table.
All right. There's been a motion and a second to gently lay this bill on the table. That's a recorded vote. The clerk would open the roll. All right. All members have cast their vote. This bill is laid on a table 7-0. Delegate Congress Fowler, if you'll proceed with your final bill, House Bill 955.
Thank you, Mr. Chair and members of the subcommittee. HB 955 clarifies that all books and records kept on behalf of the association shall be made available to member in good standing or his authorized agent in a manner consistent with the association's routine practice and procedures. Let me just stop. Everyone else gets their documents electronically. I have to go pick them up physically. That's what we have to do in this politically divisive environment that we now live in, is we have to deal with fairness and equity. So all I'm asking is that homeowners are treated the same and fairly as the common practices of the association. That's all I have to say, because I'm not sure it's going to be considered. So, thank you, Mr. Chair.
Thank you, Delegate Congress Fowler. And is there any questions from the committee for the patron on House Bill 955? Seeing none, is there anyone here to speak in favor of House Bill 955? Anyone to speak in opposition? Please go ahead.
Thank you, Mr. Chairman. Pia Trigiani, Common Interest Community Associations Institute. I mentioned before a 7,600 7,600 home common interest community. There are two unit common interest communities. There's a lot of them actually in Virginia Beach, where you have 2-unit condominiums. This bill would impose a requirement on a small self-managed community that is burdensome and costly to that community. We oppose the bill because it establishes a new requirement that records be kept electronically, that meetings are recorded. Associations should be able to choose what they want to do, how they want to conduct business. So we're opposed to the bill. Thank you.
Thank you. Is there anyone else to speak in opposition to the bill?
Mr. Chair, members of the subcommittee, Nicole Brenner with Reed Smith on behalf of the Virginia Association of Community Managers, we oppose the bill.
Thank you. Is there anyone in the virtual queue to speak in favor? Anyone opposed? All right. I don't know how we're getting this lucky. Delegate Converse-Fowler, you have the final word.
Thank you, Mr. Chair. I would just say if you read the bill, it doesn't say it does the things that it said that were just said. All it does is say that you will be given the documents in the same manner consistent with associations' routine practices and procedures for the keeping and production. It doesn't require anything additional. Thank you, Mr. Chair.
Thank you, Delegate Converse-Fowler. This committee operates by motion. Is there a motion on this bill?
Mr. Chair, move to gently lay on the table.
Second.
There's been a motion and a second to lay this bill on the table. That's a recorded vote. If all members would cast their vote, and clerk, if you would open the roll. That bill is laid on the table on a 7-0 vote. Thank you, Delegate Converse-Fowler. We will take up, let's see, Delegate Van Valkenburg. I think you were here first. We'll take House Bill 586 up.
Thank you, Mr. Chairman. Mr. Chairman, members of the committee, there is an amendment, so I guess, which is really, so I guess we should do that first. It's really just taking out the lines on 84 and 85, and Ashley has it.
Mr. Chairman, essentially, I mean, I can read them directly, but essentially what the line amendments do is remove section 36-96.3, .3:2 from the bill.
All right. There's been a line amendment to strike those two lines as reported by our counsel. Are there any questions of the committee on those amendments? If not, I'd entertain a motion to accept them.
So moved.
It's been moved and seconded. Those amendments without opposition are before us. Delegate Van Valkenburg, please go ahead.
Thank you, Mr. Chair. Mr. Chair, members of the committee, this is a bill seeking to tackle fraud for bad actors and emotional support animals, and does kind of four things. One is it provides for a Class 4 misdemeanor in cases where a person knowingly and willfully misrepresent themselves as needing an assistance animal. This is a $250 fine maximum, and other penalties are, this public intoxication, right, if it's under a Class 4. It requires a person providing supporting documentation to verify the need for an assistant animal to have a current therapeutic relationship with the person that they are getting the letter from. It makes it an offense under the Virginia Consumer Protection Act to provide supporting documentation that verifies the need for an assistant animal if the provider does not have that relationship. It will have no effect on Virginians who are getting recommended assistance with people who have an actual relationship, and this is not trying to stop emotional support animals at all for people that need them. This is just trying to put some guardrails up to protect against bad actors. And so with that, I think we've got people on both sides to testify, but I'd be glad to take questions as well.
Thank you. Are there any questions from members of the subcommittee for Delegate Van Valkenburg on this bill? Okay, seeing none, is there anyone here to speak in favor of the bill?
Good afternoon, Mr. Chairman, members of the committee. Tommy Herbert coming before you from the Virginia Apartment Management Association, as well on behalf of our sister organization, the Apartment and Office Building Association of Metropolitan Washington. We associate ourselves with the comments of Delegate Van Valkenburg. This is a bill with which we worked closely with him on. This bill simply goes after, as he noted, knowing and willful fraud. We are aware that there are concerns. However, we are understanding that the penalty laid out in this bill is precisely the same penalty that we use for fraud associated with service animals, and we are aware of no way in which this could cause a substantial equivalency problem between the Virginia Fair Housing Act and the Federal Fair Housing Act. We would respectfully ask the committee to support and advance the bill.
Thank you, sir. Next up.
Hi, my name is Troy Garrett. I represent the manufactured home communities and then also the Virginia chapter of National Association for Residential Property Managers, and we support this bill.
Thank you.
Mr. Chairman, Erin Barton with the Realtors. We also support this bill for the reasons that have already been said.
Please, thank you, and please go ahead.
Mr. Chairman, Randy Grumbine representing Virginia Manufactured and Modular Housing Association, and we too support the bill. Thank you.
Thank you. Is there anyone to speak in opposition to this bill that's here with us? Okay. Is there anyone in the virtual queue to speak in favor?
No, Mr. Chairman.
Is there anyone in opposition?
Yes, Mr. Chairman. Isabel McLean with Housing Opportunities Made Equal.
Ms. McLean, we see you, and unmute, and please go ahead.
Thank you, Mr. Chairman. My name is Isabel McLean, and I am the Research and Policy Analyst with Housing Opportunities Made Equal. Our mission is to ensure equal access to housing for all Virginians. We respectfully oppose House Bill 586 because the criminal penalties it adds would discourage legitimate accommodation requests related to assistance animals. This bill will have a chilling effect on people who truly need to live with an assistance animal, but are unsure if they qualify to do so. It is important to note that assistance animals are frequently used to support individuals coping with anxiety disorders and other mental health challenges who would feel the stress of possible criminalization acutely. We believe that a denial of reasonable accommodation is punishment enough, if the need is misrepresented. Additionally, there are already mechanisms in place to prevent false verifications, and providers are already governed by their own healthcare regulations to offer genuine documentation of disability. In addition to creating barriers for disabled Virginians, we would disagree with earlier testimony and say that the criminal penalties created in this bill would undermine the substantial equivalency between our state and federal law. HUD funds the Virginia Fair Housing Office because the latter enforces our state laws, but this funding comes into question when our laws differ from federal fair housing protections. At least two other changes in this bill would also threaten equivalency. HUD has made it clear that reasonable accommodation requests do not need to be made in writing, and they do not need to come from a current care provider, both of which would be required under this bill. So in summary, I ask you to vote against House Bill 586 for three reasons. It's unnecessary in preventing fraud, it threatens substantial equivalency, and it will greatly increase barriers for residents seeking rightful accommodations. Thank you for your time.
Thank you, Ms. McLean. Is there anyone else on the virtual queue?
No, Mr. Chairman.
Okay. Delegate Van Valkenburg, you have the final word.
Once again, the penalty is for people who willfully and knowingly commit fraud. It's not for, so I think the idea that it's going to have a chilling effect is wrong. And I think that the HUD concerns, we've talked to a variety of people, are also misplaced, but I would also defer to our experts if they want to give more. If you feel like you want more.
Thank you, Delegate. Yeah. You saw some scurrying around too. We were trying to figure out, since this bill does have a criminal penalty, if it will need to go to courts. But for now, presuming there is a motion and this bill moves forward, we're going to kick it to the full committee and decide between now and then what's going to happen with this. And with that, I would entertain a motion if there is one.
Mr. Chairman.
Move to report.
There's been a motion and a second to report this bill. If the clerk would open the roll, and members, please record your vote. This bill reports 7-0. Thank you, Delegate.
Thank you, Mr. Chair. Thank you, members of the committee.
Next up, let's see. We have a request from the patron of House Bill 702. That's Delegate Keem, to pass that bill by for the day, and without opposition, that bill will go by. Seeing none, House Bill 702 goes by for the day. We've got Delegate Willett here. Delegate Willett, if you'd come up and present House Bill 400.
Thank you, Mr. Chairman. Mr. Chairman and members of the subcommittee, House Bill 400 makes a technical update to the current law by adding the Rental Assistance Demonstration Program, referred to as RAD, to the established tax assessment guidelines for affordable housing in Virginia. For your background, in Virginia, when assessing properties in certain affordable housing programs with rent restrictions, the law requires that those properties be assessed using an income-based approach that takes into account that reduced rental stream. The list of federal programs in the current code section was created in 2006. The RAD program was not created by Congress until 2012. As such, it was not included. This bill simply adds it. And I will stop there because that is the end of my technical expertise on this bill, but I have folks here who can say more about that if that would be helpful for the committee.
Sure. Thank you, Delegate. Are there any questions from members of the subcommittee for Delegate Willett? Okay, seeing none. I do have one. Can you tell us what's in the continuing resolution from 2012?
Definitely going to call a friend. Mr. Chairman, definitely going to call a friend on that one.
You don't have to. Are there any members in the public that are in the audience today to speak in favor of this bill?
Good afternoon, Mr. Chairman. Good afternoon, Mr. Chairman, members of the subcommittee. I'm Tyler Craddock. I represent the Virginia Association of Housing and Community Development Officials. We requested this legislation. Delegate Willett has described it fully, and of course, we support it. We thank him, and we're happy to answer any questions you may have. And did you want me to answer that question, or are you just joking?
I don't think anyone in this room can tell us what's in the Federal Appropriations Act. Save it. Thank you. Is there anyone else to speak in opposition to the bill? All right, seeing none. Is there anyone on the virtual queue to speak in favor of the bill? Any in opposition? All right. Delegate Willett, you have the final word if there is anything.
Thank you, Mr. Chairman.
Thank you. This committee operates by motion.
Move report.
Second. Bill has been moved to report and seconded. That is a recorded vote. Clerk, if you could please open the roll. Looks like we lost Delegate Coiner. Delegate Willett, that bill reports 6-0. Thank you.
Thank you. Thank you.
Okay. Next up, we have Delegate Brewer's House Bill 1097.
Thank you, Mr. Chair, members of the committee. House Bill 1097 is an amendment to a piece of legislation we passed about a year and a half ago out of here, and this deals with fair housing. And this is really this amendment is really to ease the burdens for rural and private landlords. I had a ton of my constituents come to me with this exact issue, which was very concerning to them. I think in the midst of a pandemic and understanding how people felt about fair housing and the reduction of 4 units, I think what we missed is that there are a ton of people that are just truly honest brokers. I don't think there are that many people out there that are truly trying to get over on folks, and there are some people just trying to get by that came to me with this bill that use this as their primary source of income. And so in this bill, it increases from 4 to 10 units, the number in this code section. I know there will be some opposition to the bill, but just for a point of reference, there's also about $200 million left as of this morning in the rent relief fund, just so we can be aware of that. So there are abilities and avenues for folks to be able to get assistance. In addition to that, this bill has made it extremely difficult for people that just aren't tech savvy, aren't sure how to navigate the process, and it really puts them in a position to have to all of a sudden be a major business owner when their only goal was just to have a couple rental units. And so that's why I brought forth the bill.
A couple, but in this case, 10, right?
Yes, Mr. Chair.
Thank you, Delegate Brewer. Are there any questions of the patron from members of the committee? Seeing none, is there anyone here to speak in favor of the bill? Is there anyone to speak in opposition to the bill? Please come forward.
Good afternoon, Mr. Chairman and members of the subcommittee. Thank you for the opportunity to comment. My name is Brian Moorfield. I'm the Director of Research and Policy at Housing Opportunities Made Equal. Our mission is to ensure equal access to housing for all Virginians. I am testifying today in opposition to HB 1097. Housing Opportunities Made Equal runs a HUD-approved counseling program for renters with federally funded housing choice vouchers. Our counselors ensure that clients are prepared to fulfill their lease obligations as model tenants. Counselors also identify rental opportunities for which the clients are clearly qualified financially. Despite these efforts, our clients are struggling to find landlords who will accept their vouchers, even though the voucher provides a stable source of funds that can only be used for rent. This struggle is particularly acute for clients who are hoping to use their vouchers to escape neighborhoods of concentrated poverty, which is the intended purpose of the Housing Choice Voucher Program. HB 1097 would expand the number of landlords who are allowed to refuse housing choice vouchers and other forms of assistance. This reduces housing options for low-income renters, undercuts a program funded by American tax dollars, and promotes further concentrations of poverty in our communities. So for these reasons, I urge the subcommittee to oppose HB 1097. Thank you.
Thank you, sir. I think you have a few more behind you. Please come forward and state your position.
Good afternoon, Mr. Chair. Brian Kozu with the Virginia Housing Alliance. We respectfully oppose this bill. I think the legislature has been very clear through the Virginia Residential Landlord Tenant Act that persons with more than 4 units should be held to a slightly different level of accountability than kind of the mom and pop landlords, as they're most likely to not be just casual operators of rental properties. HB 6 that the delegate referenced was not something that was quickly composed. I know I spent almost a decade of work and research, both through data analysis, but also talking with property owners, tenants, public housing authorities, HUD, and we arrived at kind of this 1 to 4 carve out. So. Extending it to a cap of 10 units, we just don't know the unintended consequences. And I think that, we do our due diligence and fully understand public policy. I appreciate it. Thank you.
Thank you, sir.
Mr. Chairman, members of the subcommittee, Christy Marrow with the Virginia Poverty Law Center, and we are also in opposition to the bill. I want to thank Delegate Brewer. She was very gracious earlier, and we had a long talk, and I do understand her concerns for her constituents, but I think this is the wrong way to solve those concerns. As Mr. Koziel pointed out, the 4 or fewer exemption in this bill was the result of years of research and much conversation at this body back in 2020 when the original bill went through. And just to give you an idea of why we are opposed to expanding the exemption, it is still difficult for tenants with housing choice vouchers to find a unit that suits them. And it's not because of their budget or inability to pay. They are getting most of their rent, 2/3 approximately of their rent, paid directly by the voucher administrator, and it goes directly to the landlord, and they are able to pay the rest because it's very carefully calculated. But they are still finding that a lot of landlords don't know about this bill, and so we have this law, and so we have concerns that changing it will make it even more confusing. And then in some places, what they call the fair market rent is too high for them to be able to afford to pay even 1/3 of it. And so we ask you to not support this bill. Please do not make a process that was just about to become a little bit easier for tenants, hard for tenants again. Thank you.
Thank you. Is there anyone on the virtual queue? Jordan?
Yes, we have Mariko Lewis from New Virginia Majority.
Ms. Lewis, we see you. If you could go off mute and tell us your position, and please testify to the bill.
Hi, my name is Mariko Lewis. I'm the Housing Policy Analyst at New Virginia Majority, and we oppose this bill. When Virginia provides small landlord exemptions within housing bills, it has typically been for landlords owning less than 5 units, not landlords owning less than 11 units. And as said before, even with the current cutout, based on my rough estimations, there's likely a large percentage of affordable rental units that are already unavailable for people using housing vouchers. And additionally, based on conversations I've had, tenants who use vouchers are still having issues finding housing that actually accepts those vouchers. I would urge this committee not to increase the amount of affordable units that would be able to discriminate based on source of funds, as this bill is doing. Thank you.
Thank you, Ms. Lewis. Is there anyone else on the virtual queue?
No, Mr. Chairman.
Okay, seeing none. Delegate Brewer, you have a question. Delegate Robinson, please go ahead.
Delegate, this question is for Delegate Brewer, Mr. Chairman.
Please.
I just was wondering how you came up with 10
So I started with the number 10 for a couple different reasons. So we had an elderly gentleman in our area. And so we talk about 4 units, but to be very specific, if someone owns 2 duplexes, for instance, that actually counts as 4 total units. So in an area like mine where rental values are a lot lower than places like Northern Virginia, you're renting something out for, say, $700 or $750 a month. This is really a meager income for someone in retirement. And so I had several different people that had something in rural areas. We have duplexes, maybe quadplexes, but nothing larger like major apartment communities. And so this was brought to me by 3 different people. And I settled on the number 10 because we had a couple different folks that had duplexes and quadplexes. So we're trying to strike a balance in between not going too far and respecting fair housing, but also trying to be able to work with, small town or more rural landlords.
Thank you.
Any other questions from members of the committee? Seeing none, Delegate Brewer, you have the final word if there's anything else to say.
Thank you, Mr. Chair. I guess I would just ask the committee to consider this piece of legislation, most importantly because I think it's very important that we strike a balance. Not everyone is out here as a very large apartment community. There are some people that just own a couple units, and this is a part of their income. Some people decide not to do stocks. They decide to invest in real estate instead. In the past 2 years have been very, very difficult on many families that have decided to invest in real estate. Thank you.
Thank you, Delegate Brewer. This committee operates by motion.
Move to report.
There's been a move to report in a second. Clerk, if you would please open the roll. So my screen's not working, but I'll be an aye. Okay, thank you. Mr. Kane. Seeing that all members have voted, this bill reports 4-2. Thanks, Delegate Brewer. Finally, we have House Bill 470. That's Delegate Bulova. Please go ahead, Delegate Bulova.
Thank you, Mr. Chairman, members of the subcommittee. This bill is drawn to the Property Owners Association Act and the Condominium Act. Does 2 very basic things. The first is that it prohibits an association from refusing to recognize a licensed real estate broker that's designated by the lot owner as their official representative, as long as that designation is provided in writing. The second part deals with the association disclosure packages and clarifies that the package is due within 14 days of the request, regardless of whether that request is made from the association manager, or a third party representing the management. And unfortunately, there are some situations where third party companies will say that they are not subject to the 14-day delivery statute because the statute only refers to the association proper. That's clearly not in the spirit of the law, and so this change would make it very clear that it's 14 days of notification of either the association or the third party representing the association. So, Mr. Chair, that's all the bill does. It's a request from the Virginia Association of Realtors, and I imagine they'd be happy to take any questions if there are any.
Thank you, Delegate Bulova. Is there any questions from members of the subcommittee for the delegate? Seeing none, those in favor of the bill, please come forward.
Mr. Chairman, member of the subcommittee, Aaron Barton with the Realtors. Would like to thank the delegate for working with us on this bill. Obviously, we do support it, and I'm happy to answer any questions.
Thank you. Next speaker, please.
Mr. Chairman, Pia Trigiani, we're here in support of the bill. We had the great pleasure to work with our friends at the Realtors and with the delegate to make sure that it provides added assistance to purchasers. So we supported the bill. Thank you.
Thank you.
Mr. Chair, members of the subcommittee, Nicole Brenner with Reed Smith on behalf of the Virginia Association of Community Managers. We are also in support of the bill. No concerns.
Thank you. Is there anyone here to speak in opposition to the bill? Seeing none, is there anyone in the virtual queue?
No, Mr. Chairman.
All right. With that, Delegate Bulova, final word.
Mr. Chairman, appreciate your consideration.
Thank you. Is there a motion? It's been moved and seconded to report this bill. Clerk, if you would please open the roll, and members record your vote. Not much division in here today. That's a 6-0 vote. That bill reports. Thank you, everyone, for coming today and for your testimony. And members, thank you for having your bills in good shape. Oh, give me just a second. And request from the clerk, subcommittee number 1 will meet 5 minutes after 3 o'clock. So with that, I'd entertain a motion to adjourn. All right. Without opposition, this committee shall rise. Thank you.